All right.
Judge.
Oh,
Yep.
thanks. Okay, we are on the record. This is the matter of Charlie Kratovil versus the City of New Brunswick and Anthony Caputo. This is docket number 3896-23. Let me have, I know we have a lot of people appearing via Zoom. Let me have your appearances.
Good morning, Your Honor. My name is Alexander Shalom from the American Civil Liberties Union of New Jersey Foundation. I'm here on behalf of Mr. Kratovil, who is present to my left.
Thank you very much.
Good morning, Judge. My name is Susan O'Connor. I'm from Hoagland, Longo, Miranda, and San Dukas. I represent Independent City of New Brunswick and Director Caputo.
Okay,
Good morning, Your Honor. Vito Gagliardi from Porzio, Bromberg and Newman, representing Amicus New Jersey State Association of Chiefs of Police.
okay, and I know we have other amicus attorneys. They're appearing via Zoom. So let's see, Mr. Gagliardi, you were here previously. Mr. Disler appeared, right?
Yes,
He's
that's
here.
right.
Okay, who do we have on Zoom? Is Robert Cannon here? Or someone from Markman and Cannon? Well, why don't you tell me who is here?
Your Honor, good morning. My name is Joe Paravecchia. I'm appearing on behalf of Amicus Curiae, the County Prosecutors Association of New Jersey. I'm an assistant prosecutor in Hunterdon County.
Okay, I got your name. Is Richard D. Fortuna appearing via Zoom?
Yes, Your Honor. Richard De Fortuna, Markowitz in Richmond, on behalf of New Jersey State Lodge, the Fraternal Order of Police.
Okay. Sheila Murrigan?
Murrigan, yes, Your Honor. Good morning. Sheila Murrigan from Business Alley Law Firm on behalf of the New Jersey State PBA.
Okay, so is anyone here for the State Troopers Association of New Jersey? In the back? No? I was anticipating Robert Cannon.
Good morning, Your Honor.
Mr. Cannon?
Yes. Yes.
And you represent the State Troopers Association of New Jersey as amicus, correct?
Yes, Your Honor.
Okay. All right, so I think we got everybody. Okay. So last time you were here on August 30th, we set down today's date. In that order that I signed that day, first thing I wanted to go over with you all, I wrote on the order that today I intended to give you a final decision. A lot of that had to do with Rule 428 4D, I believe it is. The way that evolved was on the last day, September the 11th, the Attorney General's office submitted a letter indicating that they, under the rule, were choosing not to intervene in this matter. So they're out of the mix. But nonetheless, I was intending to give you a final decision today. I just wanted to get straight on that because the posture of the case was seeking interim preliminary relief via that order to show cause, which was how this case got started back in July. I think I previously asked, neither side intends to call any witnesses, is that true?
That is true.
That's accurate.
How about discovery? Is there going to be a period of discovery?
I think we agree that it's technically a legal argument.
That's where I wanted to get straight. So
Correct?
my thought is, as a matter, there is no issue of fact, but simply render it a decision as to the law, a final decision.
Judge, I think that's my understanding as well, and insofar as when I was seeking preliminary relief at the end of August, Your Honor said that the preliminary relief and the final relief were identical. Here we are.
Right.
We're at
So,
that
Connor,
time.
you agree?
I do agree, Judge.
Do you disagree? You
No, Your Honor,
Okay,
we
good.
agree.
Any of you take any contrary position on the screen, on Zoom? In other words, at this juncture, I think the case is calling for a final decision as opposed to a preliminary decision. Does anybody disagree with that notion?
No, Your Honor.
No, Your Honor.
Okay. All right. That's fine then. Well, there's more, but I poured through everything. Think I have a decent handle on this, but of course, if either side, I'll start with you, Mr. Shalom, wants to supplement the record, hit the high points or anything, by all means, the floor is yours.
Judge, thank you, and I welcome, if the court has any specific questions, I would love to answer those, assuming you'll interrupt me with any. I have 7 quick points I'd like to make.
Take your time.
Point 1, let me just give you a little roadmap. I'm going to talk about why this is not a facial challenge, but instead an as-applied challenge. I'm going to explain why the cease and desist letter is in fact a prior restraint. I'm going to talk about the question of narrow tailoring and alternatives. That's point 3. Point 4, the question of whether this is a need of the highest order. Point 5, whether or not the information was lawfully obtained by Mr. Kratovil. Point 6, the suggestion in the briefs mostly of the amici that they could play editor and tell Mr. Kratovil how to write this story. And 7th, just to talk about that the address is an issue of public concern. So that's the roadmap I plan to follow.
Go back to the first one.
Yep.
As to whether it's as applied as opposed to facial.
Yes, sir.
Okay. I'll ask Ms. O'Connor and give everybody else a chance to chime in. I accept that proposition. Do you dispute that?
I do dispute the fact that it's an as-applied challenge. All the cases that plaintiff has cited are as-applied challenges with respect to the constitutionality of the statute. It is, with respect, the heart of this case, if you will, is the constitutionality of the statute. And it goes to the effect with respect to plaintiff's 6th or 7th point with respect to narrowly tailoring it and the way the statute is written. All Director Caputo did in this instance was follow the dictates of the statute.
No, okay. The way I see it, it's as applied to Mr. Kratovil and his situation and all journalists similarly situated.
That's right. And I mean, I think the Attorney General actually lays it out quite well in their declination letter, which is to say the court isn't asked to decide whether Daniel's law is constitutional in some or even most circumstances. Instead, the only question here is whether it's constitutional under these unique facts. And the Attorney General kind of mentions 5 that I think help cabin the question. Here, Mr. Kratovil lawfully obtained the information. He did.
On that score?
We'll talk about that separately.
Well, I understand the defense position. That, I think that it cannot be said that he obtained the information unlawfully.
I think that's right.
So
that's
I don't know if you probably disagree with that, and that therefore that shuts down the whole argument. But I think the as applied goes on the shelf, and I think whether or not he obtained the information, I don't think it can be characterized as unlawful.
And I will separately talk about that, but let me just tick through the 5 factors that make it as applied. Lawfully obtained. The information is otherwise available. It is available through public searches, in fact, quite easily. Mr. Kratovil is a journalist. He wishes to publish a story, and the story relates to the residency of a high-level official in the police department. Those are the facts that the Attorney General found in their declination letter made it an as-applied challenge, and the fact that our pleadings throughout the relief we request is all as applied to Mr. Kratovil. So moving on to the question of whether or not this is a prior restraint, which I thought was a pretty straightforward question, but the city may...
On that one?
Please.
Does it matter?
Probably not.
No.
Okay, I will take your cue and move on. Let me just say one quick word. Mr. Gagliardi is here on behalf of the chiefs of police. They have a creative argument that this is actually a post hoc warning rather than a prior restraint. But
It's a penal statute.
yeah, and he's being told if he says more, he
Right.
faces consequences. Okay.
So you get past that.
Okay, so let me get to the alternatives, because I think that's a very interesting part of the question on narrow tailoring. The city's position is there are no alternatives other than to send armed guards to every public servant's home, or every covered person's home. I'll be a little more precise. We list 3 easy alternatives, again, that might not apply generally to Daniel's law, but in a situation like this, there are 3 ways that the statute could be more narrowly tailored. And the first way is the exact way that the federal Daniel's law is more narrowly tailored, because it provides an exception for journalists, for people publishing newsworthy stories. Right, so the exception is for the transfer of covered information if the information is relevant to and displayed as a part of a news story, commentary, editorial, or other speech on matters of public concern. The Congress, in passing Daniel's law, recognized this constitutional conundrum and said, let's try and prevent doxing. Let's try and prevent the widespread dissemination of the addresses of judges. They actually limited it to judges. Obviously, the New Jersey statute is broader, but said, but let's also recognize that it's different if it's a journalist trying to report on a matter of public concern. The New Jersey statutes, the absence of that is an alternative that they could have, the inclusion of that, I apologize, is an alternative that they could have utilized. Additionally, the government could prioritize policing itself, prioritize the training clerks, auditing clerks, and even theoretically punishing clerks who publish this information. One of the cases we cite on the Daily Mail line of cases is GD v. Kenny. It's the New Jersey case about expungements. And what that statute did is it penalized people who talked about expunged convictions. And Justice Albin's opinion for the New Jersey Supreme Court made clear it can't apply to ordinary folk. What it meant to apply to was government officials, to clerks who released information about, and they were subject to a $50 fine. And
Well, it's a DP, right? It was a DP.
and there's an additional fine for clerks. And so
Okay.
the absence of a provision like that puts some pressure on clerks to not erroneously disclose is another failure on the narrow tailoring front. And the last, and this is just citing to the recent Third Circuit case in Schrader, where they say anytime you have both civil and criminal penalties, it's probably not narrowly tailored unless you can prove that the civil penalties alone are insufficient. And so those are 3 ways in which I think the New Jersey's Daniel's law, as applied to this circumstance, fails the narrow tailoring test. On the question of the need of the highest order, I think there's kind of 2 conceptual things to think about. One is, in this line of cases, what are the things that have not been found to be in need of the highest order? And it's some heavy things. It's things like safety and privacy in Florida Star. And I want to focus on safety because a lot of the amici say, oh, but this statute is different because it deals with safety. In Florida Star, BJF, the plaintiff, was raped. The assailant it was a stranger rape. It was not a known person. The assailant was at large, and Florida Star published her name, subjecting her both to the theoretical risk of vengeance from this person and actual actual threats of sexual assault that she received in that interstitial period between the publication and the arrest of the assailant. So safety was implicated in that case. Nebraska Press Association dealt with the tainting of jury pools, heavy stuff. Free communication in Bartnicki. So that's one conceptual line, that there's been very serious things that the Supreme Court has said are important, but not a need of the highest order. But the critical factor, I think, here is you don't need to ask, is protecting the information of judges and police officials and so forth important? The question is the marginal benefit in this case as applied to these facts. So what you have to ask is, once you know that the government is giving out this information, as they did here, once you know that a simple Google search reveals this information, is the threat of prosecution, is that a need of the highest order? Meaning, not should we put guardrails on that prevent the dissemination generally of addresses, but once we've released it to the public, should we prevent Mr. Kratovil from publishing a story on that which is accessible more generally to the public? Your Honor has, I want to not interrupt questions.
Take your time.
Your Honor has largely said that you find that he did not obtain this unlawfully, so I won't belabor that point. I will just point out that in at least New York Times Company versus United States and Bartnicki, the information, Pentagon Papers on the one hand and a wiretap on the other hand, were actually obtained illegally by someone else.
By someone else.
And the court very clearly treated that as not illegal by the New York Times or by the folks in Bartnicki. And then there are even more cases where the information shouldn't have been released, right? Where the rules prevented the release. So in Florida Star, for example, there was a regulation, a police regulation that said don't release the name of rape victims. And they blundered. They accidentally released it, and that's all that mattered. Okay, last 2 points.
It's the same thing in Daily Mail.
Correct. In almost all of the cases, it wasn't, even in the cases that deal with youthful offenders in courts, they had a policy, don't let cameras into the courtroom or don't release the name of the defendant, and they messed it up. There are lots of suggestions from chiefs of police and other amici about how the court could read the statute narrowly to say, well, you can say Main Street, or you could say Cape May, but you can't say Main Street. You can say Cape May, but you can't say 123 Main Street. I'm obviously not using the real address. What's interesting, though, is between the amici and the defendant, no one uses the same definition of what they can and can't say. Some folks say, the defendants actually say no reasonable person could believe that the mere listing of a street name and town would violate the statute. No reasonable person. But interestingly, at the city council meeting, Mr. Kratovil only mentioned the street name and the town. And when he asked for a video through Oprah from the city said, absolutely not, that would violate Daniel's law. So we're getting different messages here. The city, the FOP says he could publish the county, municipality, general area, or distance in miles. The chiefs of police say he could state that Mr. Caputo lives in South Jersey or Cape May County. And in fact, when he was asked whether he lived in New Brunswick, Mr. Caputo had a deputy explain, and this is in our pleadings, that the public release of law enforcement officers' place of residence is protected under Daniel's law. And that was, do you live in New Brunswick or not live in New Brunswick?
Yeah, I think you're referring to Deputy Director Miller.
That's correct. That's correct. And so when you don't have clear guidance for the public, the risk is of self-censorship. The risk is that people will say less, and that is exactly what the First Amendment forbids. And so one of the key questions here is, I think everyone agrees that broadly where the director lives, distance and so forth, is an issue of public concern. And the question is it the address, or is it something more broader than that? It's too granular a view to say that the exact address is not a matter of public concern. You could also say that the identity of the rape victim is not an issue of public concern. It's the public safety on the streets of Florida or whatever. But the question is whether the issue is a matter of public concern, not the fact. So imagine that it was relevant to describe a mansion because you thought a public official was on the take. So you could describe it as a white Victorian-style 7-bedroom home valued at $1.5 million. Now, it's probably true that for the question of whether or not the person is on the take, it's only the value of the house that is critically important. But the officer on the take is not allowed to tell the newspaper how to write their story. They don't get to play editor. And in the Pentagon Papers case, it's also probably true that the Pentagon may have been happy to say, well, why don't you just report that there's an illegal war happening in Indochina, and the Rand Corporation did a report, and there was some stuff in there that made it seem like we were lying. That's kind of the nub of it. but the New York Times gets to publish the whole thing because that's how they wanted to tell the story. And it turns out, with historical hindsight, that the publication of the Pentagon Papers was incredibly important in our historical thinking about the Vietnam War. I talked about rape victims' names in both Cox Broadcasting and Florida Star. Same thing is true in Bartnicki. You could have summarized what was on those tapes and not played them, but the union official, neither the union officials nor the school board get to dictate how that story is told. The Westboro Baptist case, these people who were picketing service members' funerals, saying all sorts of horrible things, and the question was, it was outrageous stuff they were saying.
Thank you too much, Schneider.
Yeah, Schneider versus Phelps, exactly. Snyder versus Phelps. They talked about whether it was speech involving a matter of public concern. That was the question in the case, and here's how they defined it. When it can be fairly considered as relating to any matter of political, social, or other concern to the community. So it's not the fact, it's does it relate to something that the public cares about. The public clearly cares about this issue, and for good reason. You've held up the giant stack of papers. I appreciate your diligence in getting through them, so I don't want to belabor the points. If the court has any questions, I'm happy to respond to them, but otherwise I'll rest on my papers.
No, thank you very much, Mr. Shalom. Mr. O'Connor?
Thank you, Your Honor. So the two statutes at issue here are interesting because they not only prohibit the disclosure, but the redisclosure and the publication or the republication. In this case, the facts showed that there was a publication of Director Caputo's address at the New Brunswick Council meeting. Once that was learned,
Susan.
Okay, maybe just a little louder.
Thank you. I don't want to feel like I'm shouting.
No, it's just that these microphones are not the best.
Once that was learned, there was a letter sent to Mr. Kratovil on May 4th, which he received on May 15th. The plaintiff's counsel classifies this as a cease and desist letter. What it was a notification under Daniel's law with respect to the 10 days that you have to provide to a person who's trying to be an authorized person with respect to the address. There is no threat within the letter. If you look at the tone of that letter and if you look at what it imparts, there is no threat. It is just merely saying Director Caputo is a covered person under Daniel's law. This is particularly important because it has to do with the republication or the redisclosure of Director Caputo's address. There's no question in this case that Director Caputo is a covered person. And there is no question that no harm or constitutional implications befell Mr. Kratovil with respect to the initial publication to the New Brunswick City Council. The question becomes is whether or not, after written notice, which again is pursuant to Daniel's law, whether Mr. Kratovil is able or entitled to publish the address, and it's the full address of Director Caputo. Plaintiff's counsel, in his remarks, has indicated that there seems to be some dichotomy with respect to what address can be published. We've been very clear in our papers that Director Caputo's address is in Cape May. What we object to is the 123 Main Street, again, using a pseudonym, with respect to that publication. Both statutes talk about posting, the reposting, the disclosure, and the redisclosure. Your Honor is well aware of what the reasons for Daniel's law are with respect to the safety and security of the people, the public servants who serve the judiciary, that being law enforcement, judges, sheriff's officers, prosecutors. The ability for any one of these public servants to uphold their judicial or legal duties is a paramount concern and is of a concern not only federally but also statewide. We know, based upon the statistics that we've cited, based upon news reports, that there are serious and potentially fatal consequences that can occur when a public official's address is released. Those consequences could happen if Director Caputo's address is released. It is the reason why Daniel's Law was enacted by our state legislature. And that enactment has a presumption of constitutionality. The state legislature also, when they enacted it, wanted the statute to be liberally construed to affect the state policy with respect to the protection of our public servants in the judiciary. It's not only with respect to Director Caputo that's of concern, but more concerning is with respect to his family. His family is not a public, are not public servants, but yet, again, with the media, with respect to the incidents that have happened, it is the family who will bear the brunt of any issue with respect to the actual publication of Director Caputo's street address. These extraordinarily compelling circumstances and information would make the protection of public servants so that it does not interfere with their duties. The statute itself, unlike some of the cases cited by the plaintiff, does not just target the media. It targets, it applies to any person who posts, reposts, publishes, or republishes after the notice is given. As indicated during one of the questions Your Honor had, Director Caputo followed the statute. And the statute, the way it was written, permits him to provide this May 4th letter, which was received on May 15th, and with respect to the republication or the reposting. There is no loss to plaintiff's First Amendment freedoms here if he is only permitted to file his story with respect to the county where Director Caputo lives. Plaintiff is trying to explain to the court that he has a Hobson's choice. If he is not entitled to publish the entire address, then he can't publish at all. But that's not true. The matter of public concern that the plaintiff is alleging is that, and it's false, is that Director Caputo is involved in a no-show job. He lives 2 hours away. He does not appear with respect to any of his functions as a police officer. Nothing prevents plaintiff today from publishing his story with the Cape May County or Cape May City address, which would also specify how the story relates as a matter of public interest. And that's so interesting because your first question was, is this a facial challenge or an as-applied challenge? And plaintiff's counsel's remarks were that it's too granular. It's an issue and it's not the fact of where he lives. But it is the fact of where he lives. It is the fact of the protection of his family and of him. The statute itself is content neutral, and it does not curtail the publication. It is also narrowly tailored. It does not impact the right to publish any of these news articles that Mr. Kratovil wants to publish, nor is it reflected that the cases cited by the plaintiff would prohibit this publication of just the county or the town. It does not impede the public's right to know if the full address is not published. There is a balance of freedom of personal security versus an ability with respect to a public official to carry out the judicial duties that he or she is entrusted with carrying out. There is the balance that the court must consider against the magnitude of danger that Daniel's Law seeks to prevent with respect to judiciary, law enforcement, prosecutors, and their families. There is also a clear and present danger to the administration of justice. If an officer, a judge, or a prosecutor has concerns with respect to doxing or with respect to harassment or something more egregious, that impacts the way the judiciary and the judicial system works. The substantial government interest is with respect to the judiciary system working and that these concerns are real and substantial. Once Caputo's address is released, if Your Honor decides that way, there is no getting it back. The harm is done. In this instance, he would be subject to intimidation, threats, or violence, or just to those who are just trying to do their job. The statute itself is narrowly tailored because it specifies a procedure, which Director Caputo followed, and it has a narrow and specific purpose, that is to protect the judicial system. The cases which were cited in the briefs, specifically the Daily Mail, specifically talks about the First Amendment does not permit the press the freedom to publish with impunity everything and anything it declares to publish. In this instance, Mr. Kratovil, who in addition to being a publisher of a newspaper, is also a political candidate and has run for election on several occasions. I'm not impugning Mr. Kratovil's motivations, but this clearly does not explain why 123 Main Street is so essential to the position. The last thing I think Your Honor should be aware of is the public concern with respect to the separation of the judiciary. The public concern with respect to the protection of those who protect us. I do believe that this is a facial challenge because the plaintiff is talking about, well, the statute didn't say X and the statute didn't say Y in determining narrowly tailored. That is not applicable with respect to Director Caputo. All Director Caputo did was follow the statute as a covered person, notified Mr. Kratovil, and notified him in a way that merely said, I'm a covered person, these are the statutes, please be advised. For plaintiff, in this case, to specify that it's something more than the facts of this case, and it is. It is respect to the constitutionality of this statute. It is with respect to Director Caputo following the letter of the law, which is presumed to be valid and constitutional. And as such, I'd ask that Your Honor deny plaintiff's application for a permanent injunction. Thank you.
All right, thank you, counsel. Mr. Gagliardi?
Thank you very much, Your Honor. Three brief points. As the court is aware, we are here as amicus counsel for the State Association of Chiefs of Police, and we appreciate the privilege of appearing before this court. We recognize, and hopefully the court does, the unique nature of the fact that the state police chiefs, the County Prosecutors Association, and the three most prominent law enforcement unions in the state are all in agreement that plaintiff is not entitled to any relief here today. But I want to address three narrow points in pursuit of that argument beyond our brief. Plaintiff's counsel, both in his brief and in his argument today, was talking a great deal and relying very heavily on the U.S. Supreme Court decision in Florida Star and the holding there. But I want to focus the court on what the U.S. Supreme Court said in that case that it did not hold. And I'm quoting them. We do not hold that truthful publication is automatically constitutionally protected, or that there is no zone of personal privacy within which the state may protect the individual from intrusion by the press. We hold only that where a newspaper publishes truthful information which it has lawfully obtained, punishment may be lawfully imposed, if at all, only when narrowly tailored to a state interest of the highest order. Now, in relying on that case and making his argument, plaintiff has said that this is only an as-applied challenge in the pleadings, both the complaint and the brief, as well as an oral argument before this court. But then, plaintiff's counsel invites the court to essentially help rewrite the statute by identifying 3 ways that the statute could have been more narrowly tailored, such as to read as the federal law reads, with an exception for journalists writing on a matter of public concern. That there could have been a provision to train or publish clerks. There could have been a limit to only civil penalties rather than criminal penalties. That's all well and good if we were debating in a legislative committee what the law should look like. But the law is what it is, and this can only be considered as an as-applied challenge because that's how it's pled, and more importantly, I think, Your Honor, the Attorney General's office is clearly relying on the fact that we are not going to be discussing about how the statute could be modified or rewritten, because the Attorney General says, I understand this is an as-applied challenge, and that's why I'm content to allow an argument which focuses simply on the facts as opposed to the way the law could have been modified. But if we look at the law, my third and final point, if we look at the law, the issue before the court is clearly decided not by the briefs or by the arguments of counsel, but by the legislature, which has already been very clear, which prohibited the publication, if there is a written objection, to the quote-unquote home address of the public official, be it a judicial official or an official in the realm of law enforcement. Home address. So, whereas plaintiff takes arguments made by defendant and by the amici as demonstrative of the significance of his point, because we say, you could say South Jersey, you could say Cape May, you could say 2 hours away, all the rest of those things. That's a virtue, because he can say all of those things, not just one of them. He simply can't publish the home address. And we recognize, of course, that clever arguments could be made. Well, even that's not clear, right? Could he say he lives in the house between 4 Rolling Hill Way and 8 Rolling Hill Way, but wink, wink, I'm not going to tell you the address. I think we know what's going on, right? We know what the legislature meant by home address. And it didn't mean you can't say 2 hours away. It didn't mean you can't say county. It didn't mean you couldn't say municipality. You can't publish the home address. So it is, respectfully, narrowly tailored to protect a legitimate state interest. And we know exactly, sadly, what's going on in this country and why it is a legitimate state interest to protect the home address of public officials. So respectfully, we think the legislature was clear. We think the law is narrowly tailored. And to the extent the court is going to provide any relief here, we respectfully request that it be narrowly tailored, given the significant state interests and public safety involved, which were considered and addressed by the legislature in drafting the statute. Thank you.
All right, thank you. I'll give you a chance to respond, but let me just check with these folks. Counsel for Amici via Zoom, who are appearing remotely, do any of you wish to be heard? We can start with Mr. Cannon for the state.
Yes, just briefly, Your Honor.
Go ahead. You
I'm
represent
Cannon,
for the State Troopers Association of New Jersey?
State Troopers Fraternal Association of New Jersey. Yes, Your Honor.
All right, so go ahead, counsel.
Just briefly, Your Honor, with your initial inquiry from the bench was with regards to the factual questions, and do any of the amici have anything further with regards to whether the factual record was adequately established. I do point out that in his declination letter, the Attorney General wrote, whatever the merits of those claims, these are intensely factual questions. For the purposes of the parties and for the purposes of their application, their arguments today, they suggest that the factual record and discovery not proceed and that none additionally was required. I don't know Mr. Kratovil. I don't know the definition of journalist that he would fit in. The parties seem to be satisfied that he does. With regards to whether or not a Google search today performed on Director Caputo's home address would disclose the information, or how that's vital to the consideration of the matter before Your Honor, I don't know the answer to that. In regards to why is this important to the State Troopers Fraternal Association, they represent the 2,000 troopers under the rank of sergeant throughout the state of New Jersey, throughout the entire state. Their jurisdictional reach is the entire state. For the 90 communities, villages, boroughs, townships, and cities where there is no local police department, like in the facts of this case, the city of New Brunswick has a police director and a full department. The STFA and its members, the trooper, are the local police department. This same factual scenario visited upon that trooper out in the field. That person on a patch, on a Facebook, on a My Neighbors, on their own website, on their own podcast, by whatever definition of journalist or journalism might ultimately be attached to your decision here, Judge, there doesn't appear to be really any regulation with regards to that. And so as applied, really is a facial challenge if the factual record isn't established and determined. Our concern for that trooper, for our members, is that before Daniel's Law, there was no protection of their home address. None. And doxing occurred. They were subject, and there were repeated instances where troopers' homes were, and their address was being disclosed. For what newsworthy reason? This is the workaday trooper, that local cop. At the end of the day, the trooper's not interested in writing the news story for the journalist. She wants only to be assured that their home address, now protected by Daniel's Law, is not released for any reason. This is an important first step in protection for that trooper and her or his home address. This chipping away, this as-applied request, has no limitation going forward, as this matter likely will, to the appellate division, ultimately the Supreme Court. This is the first and frontal attack on Daniel's Law, and it must be seen as such. Because that limited protection provided that trooper today, which didn't exist a year ago, might just not be readily obvious and apparent after today. And that's concerning to the trooper out in the field. The STFA has gone and shouldered the enormous cost of bringing in an outside company to assist their members in perfecting their Daniel's Law portal entries, assisting them in scrubbing publicly facing websites and information that discloses their residence. Yes, it is a difficult task. Yes, there's a lot of information that Google will provide. But in taking this as applied and putting an as applied to these facts, whatever they are, even though the parties seem to suggest they're already settled, does have the impact of extending out to that other officer, to that trooper. And they don't have access to a city law department and various amici. That information will come out, it will be published, it will not be reined back, and for this purposes of your decision, if granted as plaintiff requests, then it seems that anyone will be a journalist and anyone's home address, and in particular the troopers of the State Troopers Fraternal Association, will be ground zero for the release of that information. And that's why we appreciate the opportunity to be heard and your consideration of our thoughts on this matter.
Okay, thank you, Mr. Cannon. For the record, your name is spelled C-A-N-N-A-N, and you're from the law firm Markman and Cannon. So Sheila, is it Merrigan? Did I pronounce that right?
Yes, it's Merrigan.
Okay, you're here on behalf of the New Jersey State PBA. Is there anything you'd like to say?
There's nothing additional we would like to add at this time, Your Honor. We do join in the arguments and positions of the various amicus parties and the defendant, and we would request that plaintiff's case be denied.
All right. Richard DiFortuna, you are here from Markowitz and Richmond. You represent the New Jersey FOP. Is there anything you'd like to put on the record?
Yes, if you don't mind.
Sure.
Well, good morning, Your Honor, and may it please the court. Richard DiFortuna of Markowitz and Richmond, on behalf of the New Jersey State Lodge of the Fraternal Order of Police and its over 14,000 active and retired police officers and law enforcement officials throughout the state of New Jersey. Frontline law enforcement officers who not only engage directly with individuals suspected of crimes, sometimes violently, very oftentimes unpleasantly, but are later relied upon to testify against those individuals in subsequent court proceedings. Their lives are at risk every day while on the job, and that is a given. But New Jersey has recognized that their lives and the lives of those family members who reside with them are increasingly at risk at their very homes, as individuals who have engaged with them while they are in their official capacity find it increasingly easy to locate their residences for the purposes of causing them harm. Utilizing its police power then, the state of New Jersey saw fit to enact Daniels Law as a safety measure to protect law enforcement officers and other covered individuals from harm and not to simply to protect their privacy. This is not a privacy statute, as was the case with nearly every one of the laws at issue before the Supreme Court in those cases relied upon by plaintiff, including the Florida Star case, regardless of whatever post hoc evidence submitted. I'm sorry?
No, somebody's supposed to be muted, but they're not. You can continue, counsel.
Oh, my apologies. Okay.
No, that's.
Okay. Well, again, including the Florida Star case, regardless of whatever post hoc evidence was submitted and or referred to in that opinion. And as we know, Supreme Court constitutional analysis with respect to legislative evaluations look upon the intent of the legislative body prior to the enactment of any law, not afterwards. So here we have very specific statements identifying the purpose of Daniels Law. And it's not a privacy matter so much as a safety matter. So likewise, this matter does not concern the protection of the reputational or emotional harm. Daniels Law was passed for one specific purpose, one specific, quote, need of the highest order, end quote. The health and safety of the lives of law enforcement officers and other covered persons and those who live with them while they are at their residences. Daniels Law is narrowly tailored to achieve that result as well. It simply prohibits the publication of actual residences of all said covered persons. In his papers, plaintiff tries to suggest that Daniels Law is identical to the statute at issue in Florida Star, but that is not the case. Unlike here, however, there was absolutely no evidence to suggest that the Florida legislature enacted that law for any purpose other than to protect the anonymity of rape victims. I note, too, that no one tried to publish that victim's home address either. Nevertheless, the statutes, and more importantly, their purposes are quite distinct. I note too, the plaintiff has had at least 2 opportunities to identify one other actual journalistic article wherein the actual residential address of a law enforcement or other covered person was published. To date, the closest he has come is to provide one article that published a link to a deed of a property that Supreme Court Justice Clarence Thomas sold in 2014. In other words, even if that property was Justice Thomas's residence at some point in time, it no longer is Justice Thomas's residence and hasn't been for nearly a decade. This article not only highlights yet another clear distinction between the case before you and the case plaintiff relies upon, but it also provides an opportunity for discussion of context. Plaintiff is not seeking to simply publish Director Caputo's residence, but to actually identify him as a covered person, a law enforcement officer, in doing so. This directly embraces the physical harms that Daniel's Law seeks to prevent. Likewise, therefore, this raises yet another question. What is a journalist in this day and age? Due to the internet and its social media platforms, we are all journalists. As such, any attempt by plaintiff to carve out an exception, quote, for the press, end quote, swallows the whole and eviscerates Daniel's Law, making it a nullity. Simply put, Daniel's Law very narrowly seeks to protect the lives of New Jersey's law enforcement officers and other covered persons and their families by prohibiting the publication of their residential addresses. As such, we respectfully suggest and request that plaintiffs' request for injunctive relief be denied in this case.
Okay, thank you very much, counsel. Mr. Paravecchia, you are the first assistant prosecutor, Hunterdon County Prosecutor's Office. You submitted papers on behalf, I believe, of the County Prosecutors Association of New Jersey. Do you wish to be heard?
Your Honor, good morning. Judge, we have nothing to add. We would rely on our brief as well as the arguments of defendant and our fellow amicus.
All right. So back.
Thank you.
Thank you very much. Back to Mr. Shalom. Mr. Shalom.
Thank you, Judge. I'll try to be brief and just respond to some of the things I heard. There was some talk from defendant's counsel about the presumption of constitutionality that attaches to legislative enactments. We don't dispute that that is the general rule. Here's the problem, is that, quote, in First Amendment cases, the initial burden is flipped. The government bears the burden of proving that a law is constitutional. This is in my reply brief, by the way. As the Third Circuit explained, quote, in First Amendment cases, the moving party must first make a colorable claim that the law restricts some form of speech. The government must then justify its restriction on speech under whatever level of scrutiny is appropriate. So that's just on kind of burdens and so forth. I want to say a word in response to my friend Mr. Gagliardi's point about judicial surgery, and I'm telling you how I'm acting as a legislative aid, telling you what the law should look like. That's not actually what's happening. Again, referring to the Third Circuit case in Schrader, they explain that we know narrow tailoring is a critical inquiry here, and they explain, quote, to narrowly tailor, the state must choose the least restrictive means among available effective alternatives. That's citing to Ashcroft v. ACLU, a U.S. Supreme Court case. And then Schrader continues, but there are available effective alternatives. That's the question. I'm not saying that that's how the law should be written. I'm saying the failure to enact those available alternatives is fatal to the narrow tailoring inquiry. Moving on, the defendants suggest that there is no threat because the letter that Mr. Kratovil received didn't have the word threat in it or was nicely written, but it referenced criminal statutes. It said, please don't, I'm providing you the notice and then said, and here are the statutes. And one of those statutes says it's a 4th-degree crime. Or a third, depending. And the other says you face massive fines. So the threat is pretty clearly there. And I'll note that they copied that letter, they copied on that letter the first assistant prosecutor in Middlesex County. It's hard to have less of a direct threat of more of a direct threat of prosecution than existed there. I'll note again, and I've made this point so I won't belabor it, but the idea that there's no loss of First Amendment freedoms if he limits his reporting in this way or that way, the same argument could have been made to the New York Times. Just summarize the Pentagon Papers, but no court has viewed the First Amendment in that way. Quickly, in response to a couple of the things that Mr. Cannon mentioned on behalf of the State Troopers Fraternal Association, we have argued in our papers that a Google search reveals the home address. I have the documents. I haven't included them because then they become public records, but there is no reasonable dispute about that. Both a Google search and other means of public searching, free, frankly, public searching, reveal it. And that is actually something that wasn't addressed, other than by Mr. Cannon when he talked about the ways that his client has tried to scrub the internet for their members to try and remove it. But in Mr. Caputo's case, that information is out there. There was an article written about the last hearing before Your Honor, where the court said the question is whether or not Mr. Kratovil can report on the home address. The journalist who wrote that article, I believe it was the NJ Monitor, said we were able to easily find the address. So we have a situation right now where the whole world can learn where Mr. Director Caputo lives, except the one person who can't is the person who wants to write an article critical of him. Everyone else can talk about it, find it, but not Mr. Kratovil. I want to also, and I've done this already, but there is a huge distinction between doxing that Mr. Cannon talked about, the kind of purposeless, other than threatening, release of information, and release of a home address as part of a news story. That's what the federal Daniels Law recognized, and that is true today. Last point, I will just note that though I kind of hung my argument on the failure of Daniels Law to be narrowly tailored because of the existence of alternatives, there has been no discussion of those alternatives. There has been no discussion from defendants of the availability of the address. The fact that the government gave it out and that it remains very easily, and that's just getting back to our first question about as applied versus facial, that's the basis on which this court can rule, to say whatever limitations may be placed on other people about talking about addresses, in a situation where you have a journalist, and despite whether he's also a political candidate, he's a journalist, there's no reasonable debate that Mr. Kratovil is a journalist. When you have a journalist who wants to report on an issue of public information, he's received that information from the government, and it is otherwise publicly available. In that case, the Constitution forbids the threat of prosecution that prosecution and civil penalty that Mr. Kratovil has labored under. Thank you.
All right, thank you very much, counsel, all of you, for your comments. Okay. All right. So this matter comes before the court via an order to show cause and a verified complaint filed by the plaintiff, Charles Kratovil, pursuant to Rule 4:52. The named defendants in this case are Anthony Caputo, as well as the city of New Brunswick. Charles Kratovil is a journalist who writes for an online publication known as New Brunswick Today, and Anthony Caputo is a retired New Brunswick police officer and is currently the director of the New Brunswick Police Department. Mr. Caputo also holds a high-level position in the New Brunswick Parking Authority. Now, the plaintiff, Mr. Kratovil, wishes to publish a news article which centers on the fact that Mr. Caputo, who is employed by the city of New Brunswick, resides approximate 130 miles away from the city of New Brunswick in Cape May. In other words, Mr. Kratovil wants to write and publish a story about the fact that Mr. Caputo, by residing in Cape May, is an absentee official for the city of New Brunswick. In other words, he has a no-show job. That's essentially the thrust of the story. I'll strike that. The plaintiff obtained Mr. Caputo's home address through inquiry with the Cape May Board of Elections. Now, the defense takes issue with the manner in which the plaintiff procured Mr. Caputo's address, suggesting it was obtained by ruse. Nonetheless, there was no indication that the plaintiff did anything illegal in this regard. Mr. Caputo and officials of the city of New Brunswick became aware of Mr. Kratovil's intention to print an article, or published an article, about Mr. Caputo residing in Cape May, including Mr. Kratovil's intention to include in that article Mr. Caputo's actual home address. In order to prevent the plaintiff from publishing Mr. Caputo's address, Mr. Caputo invoked Daniel's Law, which is codified at NJSA 56:166.1 and NJSA 2C:20-31.1. Daniel's Law was enacted in New Jersey in the wake of the tragic shooting death of Daniel Anderl, spelled Anderl, the son of United States District Court Judge Esther Salas at Judge Salas's home. The deranged killer, posing as a delivery man, obtained the judge's home address from an online search. The killer's target was actually Judge Salas. However, the judge's husband and her son answered the door, and the killer opened fire, shooting and killing her son Daniel and gravely injuring her husband by shooting him 3 times. By the time Judge Salas got to the front door, the killer had fled the scene and soon thereafter committed suicide. The legislature responded to this tragedy by enacting Daniel's Law, which made it illegal to publish or republish the home address of any active, formerly active, or retired law enforcement officer, judge, or prosecutor, as well as any immediate family member of an active, formerly active, or retired law enforcement officer, judge, or prosecutor. Now, in New Jersey, both civil and criminal liability can attach for a violation of Daniel's Law. The plaintiff's position is that the proscription of Daniel's Law violates his First Amendment right of free speech or free press as guaranteed by the United States Constitution, as well as Article 1, Paragraph 6 of the New Jersey Constitution. Now, given that the plaintiff intended to include Mr. Caputo's home address in Cape May in his article, let me reread that sentence. The plaintiff's position is that the proscription of Daniel's Law violates his First Amendment right of free speech or free press as guaranteed by the United States Constitution, as well as Article 1, Paragraph 6 of the New Jersey Constitution, given that plaintiff intended to include Mr. Caputo's home address in Cape May in his proposed article. The plaintiff seeks injunctive relief to bar the imposition of any civil or criminal sanctions provided for in Daniel's Law against him in the event he includes Mr. Caputo's home address in his article. As noted earlier, before we began this matter, in the very beginning, it was determined among all counsel that we're not dealing with preliminary restraints in this matter. We're dealing with a final judgment. The plaintiff does not challenge the constitutionality of Daniel's Law on its face. Rather, plaintiff maintains that Daniel's Law is unconstitutional as applied to the circumstances of this particular case. More specifically, plaintiff seeks an order declaring that 2C 31.1 and NJSA 56:8-166.1 is unconstitutional as applied to any journalist seeking to publish information on a newsworthy story. Now, plaintiff in his brief points out that the New Jersey Supreme Court often extends greater constitutional protections than recognized on the federal level. However, with regard to this case, plaintiff does not dispute that Article 1, Paragraph 6 of the New Jersey Constitution provides the same constitutional guarantees as the First Amendment of the United States Constitution. In other words, the free speech, free press analysis applicable in this case is the same under both the First Amendment to the United States Constitution and Article 1, Paragraph 6 of the New Jersey Constitution. Therefore, in this case, the Daily Mail principle applies, which comes from the United States Supreme Court decision, Smith versus Daily Mail Publishing Company, 443 U.S. 97, 1979. In accord with Daily Mail, only the highest form of state interest can sustain the validity of a government restraint on speech or the press. In other words, when a law punishes speech or publication, the government must demonstrate that the law is necessary to further the asserted state interest. This highest standard of constitutional review is also often referred to as the strict scrutiny test, which is applicable when a fundamental right such as freedom of speech or freedom of the press are involved. Under this standard of review, the government must establish that the law restricting speech or the press is narrowly tailored to achieve a compelling state interest. By narrowly tailored, it is meant that the regulation designed to achieve a compelling state interest does so by the use of the least restrictive means. Now, guidance from the Daily Mail decision comes from the following passage. If a newspaper lawfully obtains truthful information about a matter of public significance, then state officials may not constitutionally punish publication of that information absent a need to further a state interest of the highest order. That's at page 103 of the Daily Mail decision. So, there are two problems with the plaintiff's position. The first centers on whether Mr. Caputo's actual street address, in other words, the street that he lives on and his house number, are a matter of public significance. Now, the defense concedes that Daniel's law imposes no impediment to Mr. Kratovil reporting that Mr. Caputo lives approximately 130 miles away from New Brunswick in Cape May. The defense, however, does maintain that Daniel's law lawfully prevents the plaintiff from publishing Mr. Caputo's house number and the street that he lives on. Plaintiff argues that courts should be reluctant in deciding what is and what is not newsworthy, and in support of this proposition, the plaintiff in his reply brief cites the Kinsella versus Welch, 362 NJ Super 143, specifically page 154, which is an appellate division case from 2003. Lamb takes the position that whether a fact is of public interest is a decision for the news media to make, not the courts. However, in that same reply submission, plaintiff cites the Schneider versus Phelps, in which Chief Justice Roberts wrote, speech deals with matters of public concern when it can be fairly considered as related to any matter of political, social, or other concern to the community, or when it is a subject of legitimate news interest, that is, a subject of general interest and of value and concern to the public. That is at 552 U.S. 443 at page 453. Internal citations are omitted. Chief Justice Roberts noted in the Schneider opinion that a court should accord broad protection to speech to ensure that courts themselves do not become inadvertent censors. Nonetheless, the court in Schneider did decide the issue of whether the speech in question was private or a matter of public concern. In fact, Chief Justice Roberts, writing for the court, Schneider gave two examples of cases in which the court found that speech was only a matter of private as opposed to public concern. See Schneider at page 453, which is where he cites Dunn versus Bradstreet Incorporated versus Green Moss Builders, 472 U.S. 749, 1985, and San Diego versus Rowe, 543 U.S. 77, 2004. Therefore, notwithstanding plaintiff's position to the contrary, ultimately it is up to a court to decide whether or not speech deals with a private matter or a matter of public significance. Now, Chief Justice Roberts goes on in Snyder to explain how a court is to go about deciding whether speech is private or public. He wrote, deciding whether speech is of public or private concern requires us to examine the content, form, and context of that speech as revealed by the whole record. As in other First Amendment cases, the court is obligated to make an independent examination of the whole record in order to make sure that the judgment does not constitute a forbidden intrusion on the field of free expression. In considering content, form, and context, no factor is dispositive, and it is necessary to evaluate all the circumstances of the speech, or in this particular case, the proposed speech. That's Schneider, pages 453 to 454. Now, in this case, clearly the quote-unquote story, or the matter of public significance, involves the fact that Mr. Caputo resides in Cape May, which is approximately, as far as I can tell, a 2.5-hour drive from the city of New Brunswick. What street he lives on or his house number is logically immaterial to this particular story. That fact is superfluous and adds nothing to what the story is about, i.e. Mr. Caputo allegedly being an absentee non-resident official employed by the city of New Brunswick. In this regard, see the plaintiff's factual allegations in his brief dated July 12, 2003, pages 4 to 14. In other words, I find that after evaluating all the circumstances surrounding this particular case, Mr. Caputo's specific address adds nothing of public significance to this proposed news piece, which centers on the fact that Mr. Caputo's residence is situated approximately 130 miles from the city of New Brunswick. Now, for clarification purposes, one may ask, well, does it matter whether a proposed speech concerns a matter of private as opposed to public concern? And the answer to this question is clearly yes. Again, as Chief Justice Roberts explains in the Snyder decision, whether the First Amendment prohibits holding someone liable for speech turns largely on whether that speech is of public or private concern as determined by all the circumstances of the case. Speech on matters of public concern is at the heart of the First Amendment's protection. The First Amendment reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. That is because speech concerning public affairs is more than self-expression, it is the essence of self-government. Accordingly, speech on public issues occupies the highest rung of the hierarchy of First Amendment values and is entitled to special protection. Not all speech is of equal First Amendment importance, however, and where it matters of purely private significance and where matters of purely private significance are at issue, First Amendment protections are often less rigorous. That is because restricting speech on purely private matters does not implicate the same constitutional concerns as limiting speech on matters of public interest. There is no threat to the free and robust debate of public issues. There is no potential interference with a meaningful dialogue of ideas, and the threat of liability does not pose the risk of a reaction of self-censorship on matters of public import. Under the circumstances of this case, it's clear that the matter of public significance is that Mr. Caputo resides approximately 130 miles from New Brunswick. His actual mailing address, however, is a private matter, in that it adds nothing of public significance to Mr. Kratovil's proposed news piece. This story, quote-unquote story, is about distance. It is not about a specific location. Now, the second, probably more fundamental problem with the plaintiff's position is the issue of whether Daniel's law is narrowly tailored to further a state interest of the highest order. Daniel's law is designed to present, well, literally, the homicide or severe physical injury of certain government officials, i.e. covered persons, quote-unquote covered persons, as that term is defined in the statute, who are logically at risk of being targeted by violent offenders. And as noted, the law also protects the family members of those covered persons. Daniels Law applies to all persons, businesses, and associations. Everyone is subject to its proscription, and as a matter of common sense, it must be tailored in that broad fashion in order to achieve its purpose of preventing public access, or limiting public access as much as possible, to a covered person's home address. In other words, Daniels Law is as narrowly tailored as possible to achieve its purpose by way of the least restrictive means. But in order to pass constitutional muster, the purpose or the state's interest in enacting Daniels Law must be of the highest order. Writing for the New Jersey Supreme Court, G.D. versus Kenny, Justice Alvin reaffirmed that New Jersey is in accord with the federal Daily Mail principle. Not only does he cite with approval to Smith versus Daily Mail Publishing, again it's 443 U.S. 97, 1979, but he also incorporates the holding of Florida Star versus BJF, 491 U.S. 524, 1989, in which Justice Marshall, U.S. Supreme Court, wrote, "We hold only that where a newspaper publishes truthful information, which it has lawfully obtained, punishment may be lawfully imposed, if at all, only when narrowly tailored to a state interest of the highest order." Now, as noted by the Ninth Circuit Court of Appeals in U.S. versus Holland, 519 F. 3rd, 909, Ninth Circuit, this is 2008, court wrote, "We also recognize that the security of the nation's judiciary is a serious concern. We are, unfortunately, reminded from time to time that threats against the judiciary have been carried out." And in footnote 2 of that opinion, it reads as follows: "Despite security measures, threats against federal judges have taken a deadly turn. In 1979, Judge John H. Wood, Jr. of the Western District of Texas was shot to death outside his home by a hitman hired to prevent him from providing over a narcotics drug. In 1988, Judge Richard J. Duranko of the Southern District of New York was shot outside his home by a retired police officer after the judge dismissed a sexual discrimination suit brought by that officer's daughter. Judge Robert S. Vance of the 11th Circuit was killed at his home by a pipe bomb mailed by an inmate angry that his prior conviction was not overturned. In 2005, District Court Judge Joan Lefkow, husband and mother, were brutally murdered by a man whom the judge had ruled against in court. The sources, C. Rick Lyman focuses on safety for judges outside the courtroom. New York Times, March 11, 2005. Okay, and also the Chicago Tribune, March 11, 2005. Now, the wife of Judge Charles Briand of the Southern District of New York was rushed to the hospital in 1987 after eating poisoned chocolates mailed by a former university professor, jailed by her husband, Judge Briand, for manufacturing drugs in his NYU laboratory. Briand is spelled B-R-I-E-A-N-T. We are mindful that our state counterparts are also at risk. At the time of the Lefkow murders, the U.S. Marshal Service, tasked with providing security for the federal judiciary, logged roughly 700 threats or inappropriate communications against judges each year. Now that number is rising exponentially. In 2021 alone, the United States Marshal received 4,511 threats against federal judges. At the time Daniels Law was signed into law by Governor Murphy, Governor Murphy stated, "This is a renewed commitment to ensure our judiciary, prosecutors, and members of law enforcement who answer the call of justice can do so without fear for their personal safety or that of their loved ones." The then Attorney General, Kabir Grewal, said the following in support of Daniels Law: "Judges, prosecutors, and law enforcement officers all play vital roles in keeping the public safe, but in doing so, they often jeopardize their own safety, becoming targets of vengeful criminals or litigants. We need to protect them as they protect all of us. This common sense law will go a long way to ensure the privacy and security of these public servants and families." United States Senator Bob Menendez is quoted as saying, "We are living in a time of endless vitriol, rising hate crimes, and increased personal attacks. And while we may not be able to eliminate hatred from someone's heart, we can take action to better protect the men and women of our federal bench. That is why I am proud to see Governor Murphy sign Daniels Law here in New Jersey, and why I remain committed to the passage of the Daniel Andrew Judicial Security and Privacy Act in Washington." Many similar statements in support of the passage of Daniels Law were made by numerous state and federal senators. The common theme among them all was the recognition of the dire need for this law. As far as a compelling state interest, in addition to obviously protecting judges, law enforcement officers, prosecutors, clearly the state has a compelling state interest in these officials being able to do their jobs effectively, in other words, without fear or intimidation affecting the way that they do their job. Another note is, and this was quoted, cited in, I believe, Defense New Brunswick, Anthony Caputo's brief. This is a case, United States Department of Defense versus Federal Labor Relations Authority, 510 U.S. 487, 1984. In that opinion, page 500, the court wrote, "An individual's interest in controlling the dissemination of information regarding personal matters does not dissolve simply because that information may be available to the public in some form." And I think that's a very important distinction that applies in this case. So this court finds that anybody would be hard pressed to discern a state interest more compelling than that of preventing homicidal attacks or threats upon judges, law enforcement officers, or prosecutors, or members of their family. Clearly, again, as a matter of common sense, protecting the lives of these covered people under Daniels Law is a state interest of the highest order, considering the fact that literally a madman gunning for Judge Salas, posing as a delivery man at her front door, shot her young son through the heart, killing him, and also brutally shot her husband, almost killing him. A law barring the publication of or access to the home addresses of judges, prosecutors, and law enforcement officers is absolutely necessary to achieve a state interest of the highest order. For these reasons, as stated here and above, the plaintiff's requested relief is denied, and his verified complaint is dismissed. As far as a form of order, I thought to use in the initial submission, Mr. Shalom, you included a proposed final order.
I did.
I was simply going to use that order to memorialize this decision.
That's fine.
All right. the order would read, it's the order, the relief that it was sought by the plaintiff. It was actually addressed to Judge Toto, but obviously I will be the one signing it. Okay, is there anything else for the record?
I don't have anything.
No, Your Honor.
So I'll get this order signed, Mr. Sloan, it'll be up on eCourts.
Thank you.
Probably by today.
Thank you.
Okay. Counsel Amicus, anything else for the record?
No, Your Honor.
Skaggs?
No, Your Honor.
No,
No,
Your
Judge.
Honor. Thank you.
Okay, all right, that concludes this proceeding. Thank you all very much.
Thank you, Judge.
Thank you very much, Your Honor.
Thanks.
Thank you, Your Honor.